Harini Amarasuriya.
Honorable Speaker, thank you for giving me this time to make some remarks on this very important bill. In principle, we have no objection to this bill. This is something that is necessary, and in principle, we support it. But we need to ensure that the bill does not have any impact on the rights of right to expression, and especially on journalism and media freedom. And I think there are specific areas in this bill which are of concern, which could be addressed, which will make this bill stronger. So obviously, in this age of data, where data is used so widely, the protection of the data subject from abuse is absolutely essential, and there's no doubt about that. However, there are three specific concerns that have been raised by by journalists and media persons, as well as activists in the field of right to information, which I think should be considered more seriously. One is that there are certain restrictions that have been applied with regard to how journalists can access and use media, especially when processing the data, and the restrictions that are applied for media to actually use data for reporting. This is something that is causing concern among journalists about how personal data can then be used in terms of for journalistic purposes. So some definition as to the use of data for journalistic purposes could be included in this bill, because that will make this area much more clear, so that for journalistic purposes, data can be used freely. The other concern is, of course, the independence of the Data Protection Authority. Currently, all powers of the authority, including appointing members to the authority, come under the minister. Now, there is a great chance in the way the bill is currently formulated, that there is room for abuse of the powers that are given to the minister. While the current minister may say that he will assure us of the independence of the authority, you are not, Honorable Minister, going to be the minister in charge for the lifetime of this bill. So when we are drafting bills, we can't think of the bill in terms of the current minister or the current lifetime of this particular parliament. These bills go on stand for years, and the changes may occur for people who are interpreting these bills. So the important thing is to actually ensure that the bill itself is drafted in a way that reduces the possibility of abuse, that does not leave for interpretation of clauses in ways that are detrimental to the public and to public interest. So in this regard, the level of independence of the Data Protection Authority is something that is questionable. There is a great possibility that the Data Protection Authority can be used for political purposes. For instance, it is not a judicial body. It is not a judicial body, but it has powers for investigation. It has powers to impose penalties. In this regard, then the composition of this authority must ensure that there are sufficient independent persons involved in this decision making. And also, we feel that taking into consideration the powers of this authority to actually investigate and impose penalties on those who are seen to be in violation of the Act need to be considered very carefully, and there needs to be enough protection to ensure we cannot leave any room for any loopholes where political interference can undermine some of the other rights that are also enshrined in our Constitution and in other bills. There are also legitimate fears that have been raised with regard to the impact on right to information. Now, the Honourable Minister assured us that that will not happen. But if you look at the Act, page 3, Section 3, Clause 2, it says, in the event of any inconsistency between the provisions of this Act and the provisions of such written law, the provisions of this Act shall prevail. So that suggests that this Act overrides or prevails over all other existing acts, right? So how can we assure that the right to information will not be compromised by the enactment of this bill? So there are several other ways, several other rights that are enshrined through other acts, through the Constitution, including the right to freedom of expression. So how do we ensure that this bill does not restrict any of those existing rights and does not override prevailing rights that have been enshrined through other acts? So the words of the Honorable Minister itself are not sufficient to give us confidence that this bill will not undermine those existing rights. Rather, reforms are necessary, revisions are essential to make sure that there are no loopholes, that there is no possibility for this bill to actually infringe on those other existing rights. So, in conclusion, Honorable Speaker, what we feel is this bill is necessary. There's no argument about that. And the need to protect data subjects from infringement of privacy, especially not only by especially by state authorities, is something that is quite essential. There's no doubt about that. However, given the current political situation where media and the media is feeling some level of threat, where media rights have been curtailed to some extent, where media people have been attacked for their work, especially with regard to the use of media in the digital space, there are legitimate fears that this bill can infringe on the on the right to expression and also on the right to information. So as long as this bill can accommodate those concerns, can be revised in relation to enhancing protection for the right to expression as well as the right to information, there is no argument at all about the need or the logic behind enacting this kind of bill in this day and age. Thank you very much.
Honorable